Perhaps Lordship, I beg to mention item number 14 from the hearing list. Lordship, yeah, I'm led by my colleague, Time Chuba. He's some personal difficulties. It's a matter come up for 3 weeks, Lordship. 14.
What is his name?
Time Chuba.
Okay, and your name?
Foseko.
Oh, your name is here?
Yes, yes. But he is the leading, yes. He's the leading counsel.
Learned Counsel, Mr. Boseko Pote has prayed for adjournment with the consent of the other side?
Yes, Lord.
With the consent of the other side has prayed for adjournment. List after how many weeks?
3 weeks.
3 weeks.
Bless you.
Mr. Lordship, from the hearing list, item 21, Your Lordship. Lordship may let this matter be listed on refix on Thursday, Your Lordship. I've taken the consent of the petitioner.
Have no objection, Your Lordship.
All right. Learned counsel, Miss.
Ace Jillian.
Government advocate.
Yes, yeah, I'm for the
Learned
government.
advocate, Miss.
In a holy, Your Lordship.
Ina Holi, with the consent of the other side, has prayed for adjournment, list the matter on Thursday, this Thursday.
This Thursday, Your
What
Lordship.
is the date? First May.
Your Lordship, I may also be allowed to mention item 20, Your Lordship,
Mm.
on behalf of my colleague, Your Lordship.
Mm.
She's in dispose, so can it kindly be listed after 3 weeks, Your Lordship?
Once more, learned advocate, Miss.
On behalf of Livika, Your Lordship.
Your
in-
name?
My name is Inaholi, Your Lordship.
Ina Holi, on behalf of learned counsel, Miss. Learned
Livika.
government advocate, Miss. With the consent of the other side, has prayed for adjournment.
Your
List the
Lordship,
matter, when do you want?
after 3 weeks, Your
After
Lordship.
3 weeks.
Your Lordship, I may also be allowed to mention item number 6, Your Lordship. Here, the state is yet to file counter. So kindly grant 3 weeks time to file counter.
Counter.
Yes, Your Lordship.
Learned government advocate, Miss Ina Holi, with the consent of the other side, has prayed for time to file counter affidavit. List the matter
After
after
3 weeks, Your
3
Lordship.
weeks.
Much obliged, Your Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 1, Your Lordship. I'm appearing on behalf of PP Paul, Your Lordship, the leading counsel for the petitioner. Lordship is out of station, Your Lordship. So if this matter can come up after 3 weeks, Your Lordship.
Learned counsel, Mr. PV Paul is out of station. List the matter on
After 3 weeks, Lordship.
after 3 weeks.
Much obliged, Your Lordship.
Yes, Your Lordship, I beg to mention item number 7. Lordship, I'm yet to file my counter. So the counter affidavit.
Sorry,
I'm yet to file my counter affidavit.
counter affidavit, okay. Learned counsel, government advocate.
Respondent number 3.
Learned counsel, Miss
Ayala Inchin. Yes,
Ayla Inchen,
yes, Lordship.
has submitted for time to file for the respondent number has submitted for time to file counter affidavit. Learned counsel, Miss
And solo for the petitioner.
and Solo is present for, yes.
For respondent number 1.
Learned counsel, Miss
Yes,
government
Mary.
advocate.
Yes, Your Lordship.
Learned government advocate, I forgot your name. Last time I kept on
S.
asking.
Mary.
S.
S. Mary.
Maria. Is present. Learned counsel, Miss
And solo.
and Solo is present for the present for whom?
Petitioner.
This is the matter after 3 weeks.
Your Lordship, this is an interim.
Interim order shall remain in force till the next date of listing.
Much obliged.
May I please, Your Lordship?
But in item number 1, there's an interim, Your Lordship.
So item number 1, interim order shall remain in force till the next date of listing.
Much obliged, Your Lordship.
May I please, Your Lordship?
Yes, yes.
Lordship, I beg to mention item number 15, Lordship.
15?
The item number 15.
Yes.
Please let it come up after 2 weeks, Lordship.
After 2 weeks, yes. Okay. Learned counsel, Mr.
CD
Yeah.
Rumsung, Lordship,
C.D. Rungsung,
Lordship, appearing on behalf of the petitioner.
with the consent of the other side, has prayed for adjournment, list the matter after 2 weeks. Or 3 weeks, what did you say?
2 weeks, Lordship.
After 2 weeks.
Much obliged.
Your Lordship, I beg to mention item number 16, 17, and 18. It's a connected matter, Your Lordship. Appearing on behalf of my senior TB Jamir, Your Lordship.
Okay.
He's out of station, so I
Item
pray
number
that,
16,
yes, 16, 17, and 18.
16, 17, and 18.
Yes.
Okay. Who is on the other side?
We have taken consent of the other side, Your Lordship.
Learned counsel, Mr.
Peter Serto, Your Lordship.
Peter.
Peter Serto, Your Lordship.
You read, on behalf of learned counsel, Mr. TB Jamir has prayed for adjournment with the consent of the other side.
For 2 weeks, Your Lordship.
List the matter after 2 weeks.
Your Lordship. And item number 11, Your Lordship. Your Lordship, I'm appearing on behalf of my colleague I Jamir. He has recently filed his wakalatnama and would like to seek 2 weeks time, 3 weeks time to file his counter affidavit. For the petitioner.
Okay. Learned counsel, Mr. Once more, your name,
Peter Serto, Your Lordship.
Peter Sarko. with the consent of the other side, has prayed for adjournment, list the matter after 2 weeks,
Yes, Your Lord. 3 weeks.
3 weeks.
Lordship, as per last order, I was supposed to file an affidavit of service. Since they are appearing, I've also filed my affidavit of service. Taking
You
up.
file an affidavit.
Yes, I filed an
It is
affidavit.
submitted by the learned
Service upon
counsel.
respondent before is complete.
It is government advocate. Your government
No,
advocate
I'm for the petitioner,
petition. It is submitted by the learned counsel for a petitioner, Mr.
Poseco.
Poseco Forte, that a counter affidavit is.
No, sir,
He has
affidavit of
filed.
service.
Sorry,
Affidavit of service.
he has filed an affidavit of service,
Yes.
service of
upon-
notice.
Service of notice upon respondent number 4.
Service
So
of
that's
notice,
service.
respondent number 4.
Yes, I've filed an affidavit. Yes. So the service upon respondent number 4 is deemed to be complete.
Your
I'll
Lord,
have to check.
and your
Yes.
Lordship, there's a similar matter which is
Let me see.
Which
the
came up
affidavit of
yesterday.
service of notice. Give me the, just a moment.
Now today the respondent 4 they are represented.
Oh, you're reading
Yes.
respondent number 4.
Yes.
Okay, service of notice of respondent number 4. The service is complete and learned counsel, Mr. Peter,
Peter Sartori.
is representing the respondent number 4.
I, Jamir, your Lordship is representing and
On
I'm
behalf of
on
Mr.
behalf of.
I. Jami has submitted that the respondent number 4 is represented by learned counsel, Mr. I. Jami.
Yes, Your Lordship. Your Lordship, there's the connected matter which came up yesterday,
Mm.
WPC 315 of 2024.
Mm.
May it be listed together, Your Lordship.
List this matter along with the WPC number.
315 of 2024.
All right.
Oblige, Your Lordship.
Lakshman.
From the supplementary cost list for motion, item number 22.
May I please,
Oh,
Your Lordship?
yesterday's
Yes,
matter.
my lord, I have made the necessary changes.
Hmm?
I have made the necessary changes.
Hmm. Amended petition.
My lord, yes.
The joint petition, no?
Yes, my lord.
There will be dictation order, long dictation. I'll dictate. You take it down. Not very long. Considerably long. Learned counsel, Mr. M. Jami.
Takakichu. Takakichu.
Takakichu is present for the petitioners and learned PP, Mr.
Vijumomi. Vijumomi.
Viju Momi.
Not
V Momi.
Vijumomi.
Viju Momi is present. PP, no? Public prosecutor.
Lost.
Learned public prosecutor Nagali, Mr. Viju Momi is present. A joint petition has been, a joint application has been filed under section 528 of the BNSS 2023, read with Article 226 of the Constitution of India, with prayer to quash the FIR number 26 of 2023, dated 19/5/2023, corresponding to criminal proceeding in GR case number 60 of 2023, arising out of Mokokchung PS case number Mokokchung PS2. PS2 case number. Have you mentioned the case number?
Yes, my lord. 26 of 2023.
26 of 2023, under sections 506 stroke 447 stroke 143 stroke 171 F, capital F, stroke 34 of the Indian Penal Code, pending in the court of the Chief Judicial Magistrate Mokokchung. Where is the FIR?
My lord, the type copy FIR is it. The first complaint is at page number 17. This is the complaint and the FIR copy starts from page number 18. The type copy is from page number 19.
The FIR unfolds that on 18/2/2023 at about 5 p.m., a mob led by Toshi Lemba went to the informant the Chalukomba house and threatened the informant and his supporters with dire consequences. Creating havoc and panic among the supporters. Full stop. A complaint was lodged by the informant T. Chalukumba Au, which was listed as the aforementioned case. This case is at present pending at the stage of
Evidence.
this case is at present pending at the stage of evidence. And where's the ground in the petition? Which paragraph?
My lord.
Ground.
Mention about evidence, which paragraph?
My lord, para 12. Para 12. Para 12, I have mentioned that the matter is fixed on such and such for evidence.
The informant is the joint petitioner number 9 in
Nine.
this petition, and the accused persons are petitioner number 1 to 8 of this petition, of this instant petition. It is submitted that two accused, Maulung Jamir and Temjet Toshi, were not charge sheeted in connection with the aforementioned case. How many witnesses were examined?
Only one so far.
It is submitted that only one witness has been examined so far. Both the parties have amicably settled their dispute. The dispute arose on or owing to political rivalry.
My lord, yes.
Owing to political rivalry between both the parties
During the last General Assembly election.
during the last General Assembly election. Now both the parties have amicably settled their dispute. The petitioners number 1 to 8 had approached the informant, that i.e. petitioner number 9, and they both agreed, and both the parties agreed to settle the dispute amicably. It is submitted that the possibility of conviction, it's okay, no? Speed, or should I slow down? No. It is submitted that the possibility of conviction appears to be remote and bleak, and thus further proceeding will be an abuse of the process of the court. Yes, PP, anything? PP?
Lordship, to this regard, Lordship, I'm not aware, but I'm told that
Completely different case.
I have considered the submissions at the bar with circumspection. Indeed, further proceeding will be an abuse of the process of the court, as both the parties have amicably settled their dispute. Both the parties have jointly filed this petition. Possibility of conviction also appears to be remote and bleak. In view of the foregoing discussions,
My lord,
The FI
the compromise state is it page number 32.
okay. Full stop. In view, you cut that line, page 30.
32,
32.
the compromise state between the parties.
A deed of compromise has also been executed between both the parties. I have scrutinized the deed of compromise and I have a full stop. Annexure E of the petition is the deed of compromise. In view of the foregoing discussions, I deem it appropriate to quash the entire proceeding arising from FIR number 26 of 2023. All right,
My lord.
thereby the proceeding of Mokokchung GR case, have you mentioned the GR case? No, no. Or thereby the entire
GR
proceeding
60.
of GR case number 60 of 2023 arising out of so and so PS case under so and so sections is hereby set aside and quashed. In terms of the above observation, this petition stands disposed of.
Obliged, my lord.
For admission, item number 2.
Maybe
Yes,
lordship.
yes.
Lordship, kindly grant me 2 more weeks time, lordship, to file my
Weeks
reply.
time. File what?
Reply. Reply to the affidavit filed by the respondents.
Reply.
Yes, my lord.
Learned Counsel, Mr. Oseko
Okay.
Forte, with the consent of the other side, has prayed for 3 weeks' time to file a reply.
Reply to the affidavit filed by the respondents here. Lordship, there's an interim.
List the matter,
Interim.
after 3 weeks. Interim order shall remain in force till the next date of listing.
Obliged, my
Yes,
lord. Obliged, my lord.
Item number 3. 3 to 5.
May it bless your lordship. Lordship, I am for the state here.
Hmm.
I may be allowed your lordship 2 weeks' time.
2 weeks' time. Yes,
No objections.
3 to 5, no?
Yes.
Learned Government Advocate, Mr. I forgot your name, sorry.
Moa Imchen.
Moa?
Moa Imchen.
Moa Imchen. Mr. Moa Imchen, with the consent of the other side, has prayed for 3 weeks' time to
2 weeks.
2 weeks' time.
Yes. To
To-
obtain instructions.
Sorry?
To obtain instructions.
Oh, 2 weeks' time to obtain instructions, full stop. List the matter after 2 weeks. Any interim order, no?
No interim, no interim. Obliged, your lordship.
Item number 8.
May I please, my lord? Lordship, the petitioner hearing is seeking regularization of his service.
Hmm.
Lordship, the petitioner was initially appointed by an order dated 6/4/1993. The Lordship will find that at page 18 of the writ petition.
Six, 4/1993,
Correct, my lord.
page 18.
Page 18 of the writ petition, your
Yes,
lordship.
yes. Okay. Hmm.
May I read only the first para, your
Yes,
lordship?
sure, sure.
Sri T. Yanang Konyak is hereby appointed as peon on ad hoc basis in a scale of pay of such and such under the establishment of district horticulture Mont with effect from 3/3/1993. So his effective date is 3/3/1993, my lord. Your lordship, thereafter, by an order dated 18 July 2002, your lordship will find that at page 21, annexure 3 of the writ petition.
He was appointed in the year 1994.
He was appointed with effect from 3/3/1993.
3/3/1993.
Correct, my lord. Correct, my lord.
Then page 21.
Yes, then page 21, your lordship, this is an office order dated 18 of July 2002. Your lordship, the petitioner is reappointed on the same post, but with the different structures now, your lordship. If I may be allowed to read the first para again, my lord. It starts with in the interest.
Okay. Read, yes.
In the interest of public service, the following casual employees are hereby reappointed, your lordship.
Hmm.
Under the establishment of the District Horticulture Officers Mont, Nagaland, with effect from the date of their joining to duty up to 31/3/2003 in the fixed pay as shown below. Your lordship will find the name of the petitioner at serial number 6.
Yes.
So the structures now is changed to fixed pay, your lordship, from scale of pay. Now, your lordship, the state government has recently brought out a policy decision by way of an office memorandum, your lordship, which is office memorandum dated 5th of March 2025. I may be allowed to place this on record, my lord. New office memorandum dated 5th of March 2025, your lordship. There were 2 office memorandum issued on the same date, your lordship. We are concerned with the second office memorandum that is on the next page, my lord. Your lordship. I may be allowed to read this, my lord.
Yes, yes.
Office memorandum issued by the PNR Personal Administrative Reforms Department dated 5th of March 2025, subject inclusions of contingency fixed and wage paid employees as casual employees under the Nagaland Work Charge and Casual Employees Regulation Act 2001. In exercise of the power conferred by subsection 4B and C of Chapter 3 of the Nagaland Work Charge and Casual Employees Regulation Act 2001, the state government of Nagaland hereby notifies that all contingency fixed and wage paid employees appointed on or before 6 June 2016 shall be deemed to be a casual employees and shall henceforth come under the Work Charge and Casual Employees Commission and shall be eligible for the schemes and provisions so notified under the provision of this act. A verifications of such employees will be conducted and on the directions of the Work Charge and Casual Employees Commission. The employees so verified shall be eligible for regularization under clause 1, subclause 1 and subclause 3 of the schemes of regularization and absorptions of the Work Charge and Casual Employees and revision of wages notified via OM dated 17th of March 2015. So now, your lordship.
New.
Yeah, this is new. The petitioner, I have sent a letter to the department to verify and to instruct me as to whether the petitioner case can be covered by this office memorandum or not, your lordship. And I have received a letter dated 9th of April, your lordship, wherein the department is admitting that the petitioner case will be covered by this office memorandum. And therefore, your lordship, taking this office memorandum into consideration, this case can be disposed of, your lordship. I may be allowed to place this letter dated 9th of April 2025 from my lord.
Okay,
Yes, Lordship, I have no objection.
then I'll dispose it of.
Yes, Lordship.
Shall I read it, my lord?
Yes, can read it, yes.
Government of Nagaland, Directorate of Horticulture, Nagaland, Kohima, dated 9th of April 2025. Subject clarification. Sir, with reference to your letter number such and such dated 28th of March 2025 on the subject cited above, I have the honor to clarify that the casual service of the petitioner, Sri T. Yanang Konyak, on verifications by the Work Charge and Casual Commission will fall within the purview of the latest notifications dated 5/3/2025. This is for your client personal and necessary action, please. So they are admitting, your lordship, that the petitioner case will be covered by this latest office memorandum 5/3/2025, your lordship.
Lordship, only if a time frame is given by the Honorable
Yes.
Court, Lordship.
Sufficient time
How
may
much
be.
time?
3 months, Lordship.
From 3
Your
months.
lordship, 3 months may not be possible because verification, then thereafter, your lordship, it has to follow the 2015 office memorandum, your lordship. If I may be allowed to take to my lordship to 2015 office memorandum, your lordship,
Page 3.
your lordship will find that at page 26 of the writ petition. Page 26 of the writ petition, your lordship. Office memorandum, 17th of March 2015. Now, this has to be followed, your lordship, now. This has to be followed for regularizing the case of the petitioner.
Page
So-
26.
Page 26, your lordship. The relevant part, your lordship will find it at page 29. 29, para 3. Para 3, Your Lordship.
Para three.
Para 3, it's, Your Lordship, this is conditions for implementations of the scheme of regularization and revision of pay.
It is a very long.
Yes, it's a lengthy process, Your Lordship.
Procedure.
It has to go to the PNR, it has to go to the finance, then after, Your Lordship, it has to
How
be
much time you want?
at least 6 months' time, Your Lordship.
6 months?
6 months will be too long,
Too
Lordship.
long.
Lordship, as per this scheme, verification conducts twice in a year, Lordship. Once in the month of January and the second in the month of July. If my name may be included in the verification process conducted in the month of July, Lordship, it will cover. And I feel
Yes.
that is a reasonable submission, Lordship.
That day you'll have to decide amongst yourselves.
Lordship,
That your name to be
yes.
included in the list of July verification list.
Lord,
yes.
That I cannot pass any order.
In that
But,
case, a time frame may be given, Lordship.
time frame 6 months is too long.
6 months is too long,
3
Lordship.
months then
3 months, Your Lordship, practically it will be difficult.
contempt petition. Let
If-
us give.
if-
Yes, yes, because
They may file
Huh?
application for extension.
thereafter, Your Lordship, the petition will bring a contempt petition after the lapse of 3 months, because Your Lordship, see, the
They won't.
the difficulty is, Your Lordship, as with regards to the approval of the PNR and finance, that may not be a difficulty. But as far as the cabinet is concerned, Your Lordship, we don't have any authority to ask the cabinet to have a sitting, Your Lordship. So it may take some time, at least a 5 months time. A relaxation of
How old is the
one.
petitioner, how old is he?
I have served for 33, Lordship. 33 years of service.
33 years. He's not on the verge of retirement.
Lordship,
6, 3, 6, these are the
in that case,
acceptable
in 4
numbers,
months.
3, 6, but 4, 5, these type of numbers are not acceptable.
Yes, yes. So 6 is
3,
quite
6,
reasonable.
If
9,
if my name
12,
is included in
acceptable.
the July list, it will take 3 months, Lordship. And
July list.
for other necessary formalities, maybe Lordship, 4 months will be a reasonable time, Lordship.
Okay, 4 months.
If necessary, they can file extension of time, Lordship. I won't have an objection, Lordship.
Or if they,
Provided they are expediting my matter, Lordship.
Yes.
if they can give an order, they will not bring a contempt petition, then
They won't file.
a 5 months time, then at least, Your Lordship, at least a 5 months time.
Lordship, I have no objection, Lordship. 5 months. Lordship.
Yeah, 5
Lordship.
months. This is item number?
8, Lordship.
8, my lord.
Heard learned counsel, Mr. A. Angamino,
N Angami, Your Lordship.
N. Angamino.
Lordship.
I don't know why I keep on calling, referring as A, I don't know. N. Angami, I won't forget now. N. Angami, learned government advocate, no?
Senior government advocate.
Learned senior government advocate, Mr. N. Angami, for the
For the official respondents, Your Lordship.
for the departmental for the official respondents.
Lordship.
Okay. Number 1, 2, and 3, all of them.
Correct, my lord.
Heard learned counsel, Mr.
Mojime, Lordship.
Muajabe, for the
Petitioner.
petitioner, Mr. T. Yanang Konyak, who has filed his application under Article 226 of the Constitution of India for issuance of a writ or any other order, writ of any nature or any other order directing the respondents to regularize the work charge service of the petitioner as peon, or pass any orders as this court deems fit and appropriate. Full stop. It is submitted on behalf of the petitioner that the petitioner was appointed in the year
1993, Lordship. 6/04/1993, Lordship.
1983.
1993.
93, yes. So page 18, I think. In the year, appointed as
PM.
peon on ad hoc basis with effect from 3/3/1993.
Correct.
by the order number, if I'm correct, HR stroke EST hyphen 2 stroke 93 hyphen 94, which is marked as annexure 1 of the petition. On 15/7 to next paragraph. Anything else in the petition? Over and above his submission, any paragraph in the petition to be included?
No, Lordship. The appointment of
Okay.
date is very important, Lordship.
On 15/7/2022, 2002, by
18/7, my lord.
15/7.
18.
18/7, my lord. On page 21, my lord.
Page 21, no?
Yes, my lord. At the bottom part, my lord.
Is it 18?
Yes, my lord.
On 18/7/2022, 2002, the petitioner was reappointed with other incumbents by office memo number HR stroke ESTT hyphen 8 stroke 2002 hyphen 2003 hyphen 3 लिखी दिबा, हाँ, 03 लिखी दिबा. Under the establishment of the district horticulture officer, Mon, Nagaland, with effect from the date of joining duty up to 31/03/2003 on fixed pay. Full stop. The petitioner has thus prayed for regularization
In terms of office memorandum 17/3/25, Lordship.
Where is it? Which page?
Page number 27, Lordship.
Regularization in terms of office memo.
Page 26, my apologies, Lordship. 17 March 2015, page number 26, Lordship.
Yes, office memo number 17/3/2015. First of the petitioner is aggrieved by the inaction as his services has not yet been regularized.
Lordship.
It is submitted by the learned senior government advocate that recently a notification has been issued notification has been issued numbered as AR stroke legal hyphen 5/8/2024 to date hai, huh? For inclusion of contingency, fixed and wage paid employees as casual employees under the Nagaland Work Charged and Casual Employees Regulation Act 2001 by the Chief Secretary to the Government of Nagaland. Full stop. For लिखी दिया, full stop ना for. Full stop बोल रही है for. Directing that, for ना लगे, directing that all contingency, fixed and wage paid employees appointed on or before 6/6/2016 shall be deemed to be casual employees and shall henceforth come under the Work Charged and Casual Employees Commission and shall be eligible for the schemes and provisions as notified under the provisions of the this will be what act?
Lordship will find.
Nagaland, no?
Yes,
Lordship.
Nagaland Work Charge and Casual Employees Regulation Act,
yes, my lord.
2001.
Yes, my lord.
Okay, full stop. Who has written the letter and who has got the given the clarification?
Your Lordship, it is by the director. Director, who is the respondent number 2 hearing, Your Lordship. The respondent number 3 hearing.
Okay. It is submitted that a letter has been received by the senior government advocate from the Director of Horticulture clarifying that the present petitioner shall fall within the purview of the aforementioned notification dated 5/3/2025. Full stop. I have considered the submissions at the bar. The as the grievance of the petitioner has been addressed, this matter stands closed. With a direction to the respondents.
Respondents, Your Lordship.
To what was your prayer?
Regularize my service, Lordship.
Regularize his service within how many?
5 months, Lordship.
Within 5 months?
Lordship.
To make every endeavor? Or
Lordship.
not endeavor, not.
A
required?
direction, Lordship. a
Okay,
direction
now to make
regularize.
endeavor nalage. Within 5 months from the date of this order.
Lordship.
Endeavor to nalage. I've struck of the
Obliged.
endeavor word. Okay. In terms of the above observation, this matter stands closed.
Deeply obliged.
There will be little bit of tweaking and tinkering of the order. I'll correct some sentences.
Lordship.
Lordship. Much
I'm
obliged.
deeply obliged.
Thank you.
For orders, item number 9.
You keep this in record. Yes.
You have this note.
Yes, yes, in the record.
And I took steps to the respondent number 2 on 2 different occasions. The last one is on 17/2/2025. However, the respondent number 2 is yet to give appearance.
17 to 25.
Yes, my lord.
Notice has been served.
Yes, my lord, on 2 different occasions. First,
Lordship,
first is October 2024. I don't remember the date, but it's in October 2024. And after 2 months, the respondent,
Contempt over contempt. So what to do now?
Lordship, as per the order dated 18/3/2025, notice upon the respondent number 2 is still awaited, Your Lordship.
Okay, really?
yes,
Yes.
my lord. However, my lord, the respondent number 2 address is within Kohima city only, my lord. And it's been more than 2 months that I have served notice upon respondent number 2, my lord. So,
Office note dated where?
18/3/2025, my lord.
But here today we have an office note here, 23/4/25. Tracking report of the notice issued upon respondent number 2 shows that delivery was confirmed on 10/3/2025.
Lordship. Lordship, I am for respondent number 1 only, Your
I am
Lordship.
fine.
Yes, Lordship.
my lord, in that case, the respondent number 2 is not giving his appearance. So,
Hmm.
some alternate.
As
best-
it's contempt and he is not appearing after receiving any order.
Yes, my lord, that's.
This is at the stage of which, motion stage or order stage?
Order
Order
stage, Your
stage,
Lordship.
my-
stage.
Yes.
Your Lordship, the
J. Alam IS. What
Ye-
about Home Commissioner?
Why isn't my-
Why are you not representing respondent number 2?
No, Your Lordship, as far as contempt is concerned, we get instructions and letters. Yes, Your Lordship.
This personal matter.
Yes, Your Lordship.
Okay.
Lordship, if I'm not wrong, I think the respondent number 2 is implemented here. I think there was a change of guard, Your Lordship.
Looks like.
Yes, there was a change of guard, if I'm not wrong, Your Lordship. If the petitioner can verify that and then
No, my lord, he's still the one. Yes, he's still holding the post. Yes.
He will be aware because he has he is aggrieved.
Yes, my lord, he is still,
He's still holding the post.
Then your lordship sometime may be granted so that the respondent number two may instruct any of the council to appear on his behalf, your lordship. Because as of today, your lordship, I have no instruction to appear on his behalf, your lordship. And as contempt, we cannot appear without instruction, my lord.
I know.
my lord,
Maybe,
here
Any
is your
order was
lordship.
passed and that order was not followed, no? Some order was passed by this court which was not followed, maybe.
Yes.
Yes, my lord, yes.
Yes, you were saying something?
My lord, if I may allow, then I can take personal steps also. Personal, through justice service,
Okay.
so that, the court will come to know whether he is interested in appearing before your lordship.
Then he will appear, I think.
Yes,
And in office, you never know where the letters keep lying here and there,
yes, my lord.
where the notices keep lying here and there, you never know. Because a order has to be implemented. It's better to ascertain, confirm whether the notice has been served instead of taking steps.
Correct,
Yes,
Yeah.
correct, my lord.
And then it will be to your disadvantage. in
Yes,
fact.
yes, correct, my lord.
And your lordship, the order which was passed in WBC was order dated 8/4/2024, my lord.
Oh.
And to comply with the order forthwith.
More than 1 year has
Yes,
passed.
more
by.
than one, and to comply the,
Order forfeit.
yes, forthwith.
This is,
And it's almost
no
more
doubt
than
this
1 year.
petition has come up. So yes, through justice service.
Yes,
Yes. Only 1 month's time, otherwise then we can proceed with the contempt. Only 1 month's time.
my lord, can it be 2 weeks?
2
2
weeks,
weeks,
yes,
yes.
sure, 2 weeks.
Yes,
The place is nearby.
within
At-
Kohima city
Oh,
only.
in the Kohima,
Yes.
in Kohima, okay.
Yes,
All right. Item number, what item number?
9, my lord. Item number.
Learned Counsel, Mr.
Elikasi Sangda, my lord.
A. Likhasi
Sanctum.
Sanctum is present for the
Petitioner.
petitioner, and learned Senior Government Advocate, Mr. N. Angami is present for the respondent number 1. It is submitted by the learned counsel for the petitioner that notices have been issued and
On
the
two different occasions.
on two different notices has been issued on 2 different occasions and the notices have also been served according to you,
Yes, ma'am.
and the notices have also, and he has received instructions that notices have also been served to the respondent number 2. But the respondent number 2 has not appeared today. The office note dated 23/4/2025 indicates that tracking report of the notice issued to respondent number 2 shows delivery of the notice was confirmed on 10/3/2025. The petitioner may take steps to serve notice on the respondent number 2 through justice service.
Yes,
List them returnable within 2 weeks. List accordingly.
yes. Avraj.
Diploma.
Item number 10.
May please, your lordship. Lordship, on 7th of April, the petitioner was directed to take first step of dusty to respondent number 11. Accordingly, we have taken steps. So lordship, I'll file my affidavit during the course of the day.
Respondent number 11.
Yes, lordship. For former respondent.
Kohima respondent number 11.
Yes, lordship.
It's awaited.
No, I'll file my affidavit. We have served dusty service. Yes. So
Okay, your
accordingly-
service, no, you're
Yes.
you're submitting affidavit.
Yes, lordship, we have taken steps, so I file my affidavit during the course of
Sorry,
the
sorry.
day. I
didn't
file
get
my
you.
affidavit during the course of the day to show that we have taken steps.
Okay.
Yes, lordship.
No, it is already there in the office note. Service of notice issued upon respondent number 11 by the issuance number 387 dated 10/4/2025. Return of service is awaited.
Yes, Lordship. So we have taken steps.
Mm.
So I'll file my affidavit to show that we have received the dusty service
Oh,
during the
they
course of the day.
respondent number 11 has
Yes.
received.
Yes,
Okay,
Lordship.
Learned Counsel, Miss,
Petitioner, counsel for the petition.
your name?
Vikono Kiso.
Vikono Kiso has submitted that she will submit an affidavit relating to service of notice on the respondent number 11 during the course of the day. Learned Counsel, Miss, Government Advocate.
No, respond.
Ah,
9 and 10.
okay, নাম লিখি দিবাচোন দেই। তেওঁলোকৰ নাম কেইটা লিখি দিবা। Is present for respondent number 1, 2, and 3, and Learned Counsel so is present for respondent number 9,
And then
9 and 10, 1 to 8, 9 and 10. নাম কেইটা লিখি দিবা। List the matter. When do you want to be listed next?
After 2 weeks.
List the matter after 2 weeks.
Item number 12.
service, may I please, Your Lordship?
Hmm?
Service upon respondent number 5 is still awaited.
Learned Counsel, Miss so and so is present. Service of notice on respondent
5,
number 5 is awaited. List the matter after
2 weeks.
2 weeks.
Item number 13.
Yes, Lordship.
Mm.
Lordship, service for respondent 3, still awaited, Lordship. Let it come up after 2 weeks, Lordship. 1, 2, and 4 are represented.
Party, Learned Counsel, Mr.
Foseco,
Foseco.
on for the
Forte-
petitioner.
Forte is present for the petitioner. Learned Government, Senior Government Advocate, Mr. N. Angami is present. Service of notice on respondent number
3,
3 is awaited. List the matter after 2 weeks.
2 weeks, Lordship. Obligement.
For hearing, item number 19.
Yes, Lordship, my sincere apologies, Lordship. Lordship, in item number 13, there's an interim. Can let it
Okay,
continue.
13 লিখি দিলাম। তুমি আছা নেকি 13 ন? Interim order shall remain in force till the next date of listing.
Yes, Lordship. Item number 13. I'll oblige.
May it please, my lord. Lordship, as Julius Caesar said to Brutus, the fault, dear Brutus, is not in the stars, but in ourselves that we are underlings. Here as well, Lordship, the fault, the flaw is not in the law. The flaw is on the people who were in a dominating position and they have acted arbitrarily, unreasonably, and illegally, and have made the innocent contractor suffer for years together. Lordship, the facts in a gist, I'll go into the details, Lordship.
Just a moment. It will take some time now.
Lordship.
Let her go. I'll call her later.
In a gist is
You
that
call her. When it's over, you call her. Yes, yes.
in 2005, contract work was awarded to me. However,
2005.
yes, package 2, phase A, package 2, for construction of a school building, centrally sponsored school building under the,
Contract
yes,
of construction of school building.
yes, Lordship, school building, dining hall, and all this.
Mm.
Under Jawahar Navodaya Vidyalaya. Now,
Awarded to petitioner.
yes, phase A was awarded to one firm from Gauhati, Assam. Phase 2, package 2, phase A, package 2 was awarded to, package 1 was awarded to the Gauhati firm, MS Tripini Construction Private Limited, Gauhati, Assam. Package 2 was awarded to the present petitioner. Now, because of insurgency problem, unmotorable roads, and this is in a region considered to be a backward area within Nagaland state, Tuensang district. So no raw materials were produced, and as it is for a state such as Nagaland, Lordship, we import most of the construction materials from our neighboring states such as Assam, which is common knowledge. We don't have any notable construction industries here. And there was washing away of roads. In fact, one of the engineers of the respondents also, that is Rights Limited, was also abducted by the insurgency group. The petitioner, because he is a local person, the rights engineer, they are from mainland India. So he had to run from pillar to post in order to get the engineer released. Now, because of all this, the firm from Gauhati, MS Tripini, who was awarded package 1, they also left, saying that no, this is impossible for us to be executed. So they also abandoned the project. But where is me in the interest of the school children?
Yes.
I pressed on. Bridges were washed away, roads, there were landslides, all this I have mentioned in my petition. I'll take my lordships to it. Now, in 2011, 3 more additional, in my package 2, there were 2 main buildings. One is the dining kitchen, and the other is the school building. The school building, it was inaugurated, it is already functioning, and it is functioning till today. The dining kitchen portion, when it was still incomplete, another 3 works was awarded to me by later dated 26th of September 2011, which I have annexed at Annexure 9 of my writ petition. Now, by that letter, I was awarded 3 more additional works. That is boundary fencing, retaining wall, and playfield.
Annexure what?
Annexure 9,
9 page?
99 and 100. And I was told that since it was already 2011, the work was awarded in 2005. It is common knowledge that the prices of the materials, the cost of labor also increases. So it was mentioned, categorically mentioned in the letter, that the price has been revised. It has been increased, in other words. Now I diligently completed those 3 additional works: the playfield, the boundary fencing, and the retaining walls. And I submitted my bills. However, surprisingly, the respondents, they paid me as per the 2005 rate, not as per the 2011 rate. So I was shocked. I told them, no, if I continue in this manner, at this stage, in this price, at the rate that was existing in 2005, I'll incur, instead of making profit, because me being a contractor, my intention is also to make at least some marginal profits. So instead of incurring, even forget about making a marginal profit, I'll incur losses. So it is impractical, impossible. And your non-revision after rates has frustrated me from performing the contract.
Yes.
So after the school building has been completed, the second building, the dining midway, I stopped work because there was apprehension that I will be paid as per the 2005 rate and not as per the 2011 later dated 26/9/2011, which I have annexed at the cost of repetition. Annexure 9, pages 99 to 100 of my petition.
So that after completing the school building,
Yes.
any other work allotted?
Yes, other 3 works, additional works also I completed. The school building was completed, the boundary fencing was completed, the play field was completed, the retaining wall was completed. Now only the dining hall remained. Now midway through that construction of the dining hall, my
Okay.
contract was terminated.
Hmm?
So my contract was terminated. So because one, I refused to work under the 2005 rate. Since it was them who gave me the letter saying that your
Okay.
amount has been revised. And now when I have completed the work, they refuse to pay me as per the revised rate. So I stopped work, which is a reasonable reaction from the petitioner. Now, since I refuse to work as per the 2005 rate, which I believe will be only 25% of the balance work.
Mm.
They issued termination letter. So I approached the district judge at Toensang by filing a civil suit. Now, when the suit was pending, the respondents, the defendants therein, they approached me saying that let us resolve this amicably outside the court. So you withdraw your civil suit. So likewise, in good faith, I withdrew my civil suit. Now again, after withdrawal of my civil suit, I was invited to Delhi. Now, not just once, but several times. So at the cost of time and money, I stayed in Delhi on several occasions. And finally, when I got to meet them, I was made to sign a supplementary agreement.
Supplementary what?
Supplementary agreement, which I have annexed Annexure 16, no, Annexure 17. Supplementary agreement is page 100 and type copies at page 122.
Annexure
223.
what?
Annexure 16. Annexure 16.
Page 200.
Page 120 and 121 is the original copy, that is the photocopy, and 122 to 123 is the type copy. The original copy is also readable. However, in this supplementary
Agreement.
yes, agreement also, I was told that there will be no revision of rates. You either complete your work, the remaining work as per the old rate, or that is 2005 rate, Lordship. In 2007, they are insisting 17. After 12 years after the execution of the original agreement, they are insisting me to work under the 2005 rate. And after that, I was allowed to, on paper, continue the work. Now I say that no, this cannot be done. Because
okay,
I will incur losses. So now, by the documents that I've impugned in this writ petition. Annexure 27,
Page.
page, my lord, 27, 137, Lordship.
Okay. I got it.
Yes.
Okay.
I have reproduced the relevant portion at paragraph 22, at page 42 of my writ petition. I believe it will be more convenient to read from the
Para
22.
22 of the petition.
Yes, Lordship.
Okay.
I have reproduced the entire body. Now, I may be allowed to read this.
Yes.
This is important. I may be allowed to read from the paragraph 22.
Yes. Yes.
In spite of the notice that 22, that thereafter the General Manager Rights Limited impugned letter of termination number so and so dated 21/9/2020 unilaterally terminated the contract. Relevant part of the said letter is reproduced here below. In spite of the notice issued to you through letter under reference in connection with the work to be executed under the above mentioned contract, you have failed to lift suspension of work imposed by you without any reasonable cause and proceed with the work with diligence. Complete the work within the stipulated date of completion of 22/10/2017. Your reply with your letter number dated 2/12/2019 and letter number so and so in response to the show cause notice has been considered carefully but not found to be satisfaction of the engineer in charge. All these letters I have written to them requesting them to revise the rate or pay me as per the yes, at least 2011 rate, but they refused. Therefore, the underdesigned General Manager of Rights Limited, acting for and behalf of the agent, power of attorney holder of NVS in exercise of the powers vested in me in terms of clause 3 of the contract and without prejudice to any other right or remedy which shall be accrued or shall accrue hereafter, do the employer under the terms of the above said contract hereby terminate your contract on account of your default, and the said contract shall stand terminated with effect from 21/9/2020. 2. You are advised that with the termination of the contract in your favor in terms of clause 3 of the contract, your earnest money deposit, security deposit already recovered and performance guarantees under the contract shall stand forfeited and shall be absolutely at the disposal of the employer. Now, this is what aggrieves me, because the security deposit, earnest money deposit, all these are my money. Performance guarantee. 3, you are accordingly requested to report to Office of Senior Deputy General Manager in person or through an accredited representative of Rights Limited, so and so, on 12/10/2020, where an inventory of complete incomplete works will be made and recorded jointly. In the event of your failure to keep up in this appointment, inventory will nevertheless be prepared, notwithstanding your absence, and the same shall be final and fully binding on you. Please note that in terms of the provisions under clause 3 of the contract, the works remaining unexecuted by you and now taken out of your hands will be executed by another contractor, and you will not be allowed to participate in the tendering process for the balance work. Any excess expenditure incurred or to be incurred by Rights NVS in completing the works or parts of the work, or the excess loss or damages suffered or may be suffered by remedy available to Rights NVS in law be recovered from any monies due to you on any account of. If such money are not sufficient, you shall be called upon in writing and shall be liable to pay the same within 30 days. Total cost of the work to be incurred on completion of leftover works is being worked out and which shall be communicated to you soon. Now, they are saying that the remaining balance of the work which are refused to perform as per the 2005 rate will be tendered and will be executed by another contractor, and that amount shall be paid by me. There is another letter also in continuation to this, which I have also impugned in the petition. There they have quoted the amount which I am supposed to pay. If the recoveries above to be met, which taking action as stipulated above are in excess of the security deposit forfeited, this shall be limited to the amount by which the excess cost incurred by rights and NVS exceeds the security deposit so forfeited. It may also be noted that in terms of clause 3 of contract, with the termination of contract, you shall have no claim to compensation for any loss sustained by you by reason of your having purchased or procured any material or entered into any engagements or made any advances on account or with a view to execute the work or performance of the contract. You shall be entitled to be paid only for the work actually performed under the contract up to the date of termination of contract as certified by Senior Deputy General Manager rights. This is without prejudice to any other right or remedy which shall have accrued hereafter to the employer. Please acknowledge the receipt of this letter. Now, this letter was issued during the COVID-19 pandemic, 2020. And at that pandemic time, I was asked to come to New Delhi. So from their actions, my Lord can comprehend the harassment, the abuses that I was allowed to undergo, that I was made to undergo. Now, insurgency in early from 2000, prior to 2010 was a huge problem in Nagaland, which is why even the Union of India, the central government, have executed ceasefire agreements with these insurgency groups. Now I am a mere contractor. Now it goes without saying that this insurgent group have huge organizational strength. I'm powerless against those. Now, at one point of time, they even came and set up camp with their arms, their personals at the construction site. So all the laborers, they ran away, including the skilled laborers also, which I have to bring in from neighboring states such as Assam, even Bihar.
Okay.
All these are also in the knowledge of the respondents. Though today they deny the knowledge of those incidents happening. Now, in between the letter that I have read out, Annexure 27, and Annexure 33, there are also other correspondence also, but which were written by the petitioner to the respondents to resend the letter and to reconsider, but nothing happened. Now, lastly, another email was received by the petitioner, which I have annexed Annexure 33, the last page of my petition. That I have reproduced at page 58, paragraph 55 of my writ petition.
Okay.
Paragraph 55, page 58.
Quite a long read petition.
Yes.
Yes.
There were too many correspondences between the
Yes.
petitioner and the defendants. In order not to waste the time of this honorable court, I'm not reading all the annexures. Now I may be allowed to read this because I have impugned this annexure 27 and 33, the previous letter that I have read out, and this document, these two documents I have impugned in this petition. I may be allowed to read para 55, yes. That day after the petitioner had received impugned letter number so-and-so, dated 4/11/2020, written by Senior DGM Civil Rights Limited on the subject construction of Phase A, Package 2, buildings for JNV at Chari, District Toensang, Nagaland, agreement number, rights CP so-and-so, dated 22/8/2005. Relevant part of which is reproduced here in below. Please refer rights letter dated 21/9/2020, cited under. This is the letter that I have written, that I have read out. Reference above, wherein you were requested to report to Office of Senior Deputy General Manager in person or through an accredited representative at Rights Limited, plot number so-and-so, for preparation of inventory of complete incomplete works. Since you failed to keep up this appointment and have not executed any works since 14/7/2017, measurements recorded in 9th running account bill. Therefore, measurement recorded in running account bill dated 14/7/2017 are being treated as final. Consequent upon termination of contract and in accordance with clause 3 of contract, EMT and or full security deposit recoverable under the contract shall be liable to be forfeited, which works out at 13,60,189, which is 10% of 4,36,01,897. Now, therefore, in addition to an amount of rupees 29 lakhs already recovered as security deposit, and the amount, this is the previous paragraph is earnest money deposit, EMT is earnest money deposit. The present one is the present amount of 29 lakhs is security deposit, and the amount of 13,59,389 withheld against milestone plus 10,07,161 withheld against approval of deviation and rupees 60,000 withheld against others. Withheld in the 9th running account bill is also being forfeited as security deposit amount. Further, the above, you are also requested to deposit an amount of rupees 84,977 rupees 43,60,189.70 recoverable amount minus rupees 29,15,823 already recovered security deposit, rupees 13,59,389 amount withheld and proposed to be recovered as shortfall in the recoverable security deposit within 15 days of issue of this letter. So,
This you got through email.
yes, through email. So all this earnest money deposit, security deposit, they have withheld. And this honorable court, at the stage of motion, was pleased to state this annexure 33 as well as 27. But despite that,
Yes.
the money is with the respondents.
Yes, yes.
Now,
And they'll recover it also.
yes. Now, at this stage, my humble prayer before this honorable court is that, because of course I pity the students.
Yes.
I also want to,
They need the dining
yes,
hall.
yes,
True.
want
Is
to
there a
complete,
stay in this petition?
there is no stay.
No stay.
But since my
What about
contract
the
is terminated,
construction of the dining hall going on?
no, nothing is going on. In fact, the package one also, it is still lying as it is.
Hmm.
They have not retendered the remaining work because Triveni,
There other contract or work or tender or anything floated, any stay or over there? No, nothing. No
that
stay.
I am not aware of.
No, it will be in this petition only.
Yes, yes. Now, since my contract has already been terminated, and since I cannot work in the old 2005 rate, the balance work so far as package 2 is concerned, it is existing as it is. But at the cost of repetition, I have completed the school building, which the inauguration pictures are also annexed here. It was also
And
published
the
in the,
additional work also you have completed, except the dining hall.
yes, yes, additional works also I have
But
completed.
that is very important for the student
Yes, yes, yes. Now,
coming from far places.
yes. But despite that, I have also run into huge financial losses because of this.
Mm.
The loans that I have taken from the banks and from other, even personal loans from non-associates, I had to recover from my pocket, and now I am in a bad financial shape. So I only want my money back.
Yeah.
And if
Yes.
I am to be allowed to continue with my work, with the balance work, then I have to be made to continue as per the revised rate, the existing rate, not as per the 2005 rate. However, that liberty may be given to rights.
Okay.
Now, rights in their affidavit in opposition,
Mm.
they have stated only one thing regarding jurisdiction. There is an agreement in the contract that the jurisdiction rights affidavit to you. Shall be at New Delhi.
Mm.
Now, this is not enforceable because as per section 28 of the Interim Contract Act, jurisdiction of courts cannot be ousted by private agreements. There are a plethora of cases on this. I may not waste the time of this honorable court replacing those, but I may only be allowed to read section 28 of the Interim Contract Act.
Okay.
Agreements in restraint of legal proceedings void.
Mm.
They are not voidable. They are
You
void
have the
agreements.
contract, yeah? All right. Yes, yes.
So let me not, or shall I read
Yes, read it.
28? Agreements in restraint of legal proceedings void. Every agreement, A, by which any party thereto is restricted absolutely from enforcing his rights under or in respect of any contract by the usual legal proceedings in the ordinary tribunals, or which limits the time within which he may thus enforce his rights, or B, which extinguishes the rights of any party thereto, or discharges any party thereto from any liability under or in respect of any contract on expiry of a specified period so as to restrict any party from enforcing his right is void to the extent.
Okay.
And in order to make things clear, there is no arbitration clause in this
Okay,
agreement.
okay. All right. In that.
So this court, this
No
honorable court,
arbitration clause in the
no,
agreement.
no arbitration clause. Otherwise, we would have proceeded for arbitration.
Yes, definitely.
Now, in the impugned letter at Annexure 22, no, 27 and 33, which I have read out. In those two letters, they have not mentioned any loss which was incurred by Rights Limited due to the non-execution of the work in the 2005 rate by the contractor. Now, when there is no loss incurred, and they cannot improve their case at this stage by filing an affidavit, the law is clear. Now, under such circumstances, my security deposit, it cannot be forfeited in favor of rights. It has to be returned to me. The earnest money deposit, the performance guarantee. I may be allowed to rely on 1973 AIR SC 1098.
AIR 1973 SC
1098.
1098.
Yes, Lordship.
You give me a printout of this, huh? Yes.
I may be, it's a very short judgment, 6-paragraph judgment, yes.
Yes, yes.
I may be allowed to rely on paragraphs 4 and 5. 4. It is important that the breach of contract caused no loss to the appellants. The stipulated quantity of rum was subsequently supplied to the appellants by the respondents themselves at the same rate. The appellants, in fact, made no attempt to establish that they have suffered any loss or damage on account of the breach committed by the respondents. Assuming that I have breached, Lordship. Following the decision in Matila Box's case, we hold that the High Court was right in rejecting the appellant's claim that they were entitled to forfeit the security deposit. Civil appeal so-and-so is accordingly dismissed with cause. So Supreme Court imposed cost upon these respondents. For taking the security deposit of the now another decision, Lordship, 2004-3,
Yes.
381 paragraphs,
SCC.
2004-3 SCC 381, para 11 and 12.
Okay.
Chai Turka Finvest Private Limited versus State of Haryana. Here, the facts was that sand mining lease was awarded to the contractor. However, state did not compensate the land on which the sand was to be mined, and his contract was frustrated. And security deposit, all this was forfeited. So Supreme Court has said that no, it cannot be done. I may be allowed to read paragraphs 11 and 12.
Yes, yes.
It is not in dispute that the Crown of Mining lease in favor of the appellants herein for the extraction of mineral sand by the respondents is governed by provisions of the Punjab Minor Mineral Concession Rules 1964. In terms of Rule 13, the bidder is required to execute a deed in Form L, Clause 27 of the agreement in Form L obligates the respondents to comply with the request made in terms thereof. The appellate authority had not considered this aspect of the nature of the matter. The High Court also did not apply its mind in this behalf. The first question that arises is whether the respondents complied with the statutory obligations when the request was made by the appellant. If not, the second question would be the effect of non-compliance with the statutory obligation of the respondents, which form part of the contract insofar as they did not comply with the appellant's request, as aforementioned, which had the direct bearing on the right of the appellant to rest sand. The High Court has, as noticed here in before, has merely proceeded on the basis that the appellant had entered into the contract with his eyes wide open. But the same would not, in our opinion, mean that they were bound to pay the contract amount get its security amount forfeited, as also pay interest at the rate of 24%, although it could not by reason of acts of omissions and commission on the part of the respondents carry out the mining operation as per the terms of the agreement. Whether in such a situation the doctrine of frustration will be invoked or not should have been considered by the High Court. CMT Army Welfare Housing Organization versus so and so. Therefore, here also the Supreme Court held that security deposit cannot be forfeited. Now, I believe it will be essential to take my lord to page 99 and 100 of the writ petition. In order to satisfy this honorable court that the respondents state themselves have written a letter to me saying that the rates have been revised.
Yes.
Page 99 and 100. I may be allowed to read.
Yes.
Subject, Phase A works at JNV, Tuensang, Nagaland, regarding approval of RE-RPE. The revised preliminary estimates for the above work submitted white letter under reference has been examined, and I am directed to convey revised AA and ES amounting to rupees 1,310.93 lakhs, rupees 13 crore 10 lakhs 93,000 only. Now, my lord, in order to be clear, this Phase A has two packages, like I have been stating from the beginning, yes. So it includes both package A and package B. Package one was also revised, and package 2 was also revised by the same letter. Against the revised so-and-so, lakhs that of rupees 937. So earlier it was 937 lakhs. So it was revised to 1,310 lakhs, 0.93. And by this same letter, if the at page 100, at items 10, 11, and 12.
Yes. All right.
Additional works were awarded to me. And in item 1 is the school building, which I've already completed. Item 3, the dining and kitchen and dining block. This was also revised. But when the payment was actually made,
yes,
and rights, they are now saying that I should go to NVS because it is the central government which have engaged rights. This is the public enterprise through whom the work orders are awarded and work is being overseen. Money is also being given through them. Now, when I say that I may be given as per the revised rate, they are saying that no, you go to the union government. No. That's how I have been made to suffer for years together. And at paragraph 6 of my writ petition, I have given the details of how there was and why delay occurred in the execution of the work.
that you have explained also
Yes.
in your argument.
Yes.
Okay, give me 5 minutes break. EP. Only 5 minutes. I'll come back again.
My lord.
For 5 minutes. It'll take some time, no? Your side?
Yes.
Your side also, it'll take some time. Only 5 minutes.
Okay.
Did you call it?
어, 여기 주었나? 라이트 상에서 눌려. 아니야, 라이트 맞아. 어.
Yes.
Now,
Go on.
regarding revision of rates,
Regarding,
revision of rates,
sorry,
revision,
of rates.
increase
yes,
of
yes.
rates, yes, because inflation is a normal
Yes.
incident of market. On that, I may be allowed to place two citations.
Yeah.
In order to satisfy this honorable court that I cannot be coerced, I cannot be forced to work under the 2005 rate.
Mm.
1996, AIR, Supreme Court 782.
Sasma. Yes,
Paragraph 8.
right.
Yes, my lord. I may be allowed to read.
Yeah.
Yes. 8. Admittedly, under the agreement, the completion period of work was 28 to 1999. The stipulated quantity of work in respect of item number 13 was 57,000 cubic meters, and in respect of item number 12 was 3,500 cubic meters. In the course of execution of the contract, drawings and designs were changed, as a result of which there was abnormal increase of the quantity of work, and for such increase of quantity of work, when the contractor claimed a higher rate and gave the analysis before the arbitrator, which was not disputed by the state, and the arbitrator accepted the rate, the court will not be justified in interfering with the same. It is not possible for us to accept the contention of Mr. Sekal that under the terms of the agreement, the contractor was not entitled to claim any higher rate. The arbitrator, having considered all the relevant materials, and there being no legal proposition which has formed the basis for acceptance of a higher rate, and on the other hand, the same being arrived at on account of the abnormal increase in the quantity of work which was account of change of drawings and designs, the court will not be justified in interfering with the same. So the increase in rate was also accepted here. Here also, in my case also, there was delay in the financial progress, there was delay in furnishing me timely drawings, sketches in time. I have stated those in paragraph 6. Now, I may also be allowed to rely on 1989 AIR, Supreme Court 1034, PM Paul versus Union of India. Para 12.
You have the book?
1989, Supreme Court AIR 1034.
1989, no?
Yes, my lord.
Para 12.
Yes, para 12.
Yes.
In the instant case, page 1037, para 12 is at 1037. In the instant case, it is asserted that the extension of time was granted, and the arbitrator, like in my case, has granted 20% of the escalation cost. Escalation is a normal incident arising out of gap of time in this inflationary age in performing any contract. The arbitrator has held that there was delay, and he has further referred to this aspect in his award. The arbitrator has noted that claim 1 related to the losses caused due to the increase in prices of materials and cost of labor and transfer during the extended period of contract from 9/5/1980 for the work under phase 1 and from 9/11/89 for the work under phase 2. The total amount shown was rupees 5,47,618. After discussing the evidence and the submissions, the arbitrator found that it was evident that there was escalation, and therefore he came to the conclusion that it was reasonable to allow 20% of the compensation under claim 1. He has accordingly allowed the same. This was a matter which was within the jurisdiction of the arbitrator, and hence the arbitrator has not misconducted himself in awarding the amount as he has done. Now, time was extended, in my case also.
Yes. Yes.
But
money was not.
yes. And in 2011, they said that it has been revised. But when actually I submitted my bills, they paid to me only as per the 2005 rate. And rights, they are now saying that no, you go to the Human Resource Development Ministry, because this is, NVS is under the Human Resource Development, and NVS has engaged rights. And rights have engaged me. So HRD, the Human Resource Development and the rights, they are master and servant.
Okay.
So my humble prayer at this stage is that the security deposit, performance guarantee, and the earnest money deposit that I have made, it may be repaid to me, it may be returned to me, and the impugned letter, which I have annexed at Annex
Two
23,
impugned
yes,
letters,
yes,
Okay.
as well as Annex 33, 27 and 33, it may be questioned side aside to the extent that my security deposit, earnest money deposit, and performance guarantee stands forfeited. And as for the whether to allow me to
Carry
perform
on.
the remaining portion of the work under the new revised rates, under the existing rates, it may be left open for the respondents to consider. I rest for the time being, subject to,
Okay, you.
I reserve my,
reply.
yes, my right to reply.
Yes. Leadership, I'm applying for resolution 1, 3, and
Can you remove this? This
yes.
little bit, I cannot see. Yes,
1, I'm applying for resolution 1, 3, and 6.
1, 3, and 6.
Yes. So, the resolution number 1, 3, 6, they are just a Kohima respondents, Leadership, and no claims has been made in the petition as against the resolution number 1, 3, and 6. So I have nothing much to say in this petition. Only I want to make that the contract was ended between resolution number 2, 4, and 5.
Okay.
So the petitioner has admitted that the rights, that is the resolution number 2, is the agency of NC and such answering to bottom praise that Union of India and NVC be elected as a party respondent in the instant case. No, I may be allowed to read just one para of my affidavit. One para.
Of your affidavit.
Yes, Lordship. Para 6,
Respondent number 1, 3,
1,
and
3, and
6.
6.
Yes, please read. Which
Yes.
paragraph?
Page 5, para 6. Lordship.
Yes.
So short para, let me read, Lordship.
Hmm.
That with regard to para 6, 7, 8, and 12 of the answering report states that the petitioner has no legal rights to get any relief from the Navataya Vitraya Samiti, and referred to as the NVS, as the contract was entered between resolution number 2, 4, and 5. The petitioner has admitted that rights is an agency of the NVS, and as such, answering deponent praised that the Union of India and NVS be elected as a party respondent in the same case. Sub-parallelship. It is admitted that on the request of rights, NVS right date number so and so, dated 29/9/2011, come with a revised amounting to rupees 1310 lakhs against the so and so, which was issued by the NVSC on the request of rights against the original rupees 788 lakhs with the direction to the construction agencies, that is rights, to complete the work in all respect within the revised sanction amount within the stipulated time. Further, the contract agreements signed between the petitioner and respondent number 2, 3, and 4 bind the parties to the contract and not the NVS. Since all the contract was entered into between the respondent number 2, 4, and 5, all the claims is against the respondent number 2, 4, and 5. And such the answering respondent 1, 3, and 6, we have nothing to say. That I'll rest for now. But if any in the afterward, if any that needed to be submitted, I'll give you the opportunity. Next, Lordship. Lordship, I'm for the responder 2, 4, and 5 rights. Lordship, Lordship, I may be allowed to take you to my affidavit.
Yes.
My
2,
affidavit,
4, and
page
5, yes.
2, 4, and 5. my affidavit at page 3, paragraph 4. Before going to the pairwise, or if I may be allowed to raise a preliminary objection, the maintainability of the writ petition. Lordship, I may be allowed to submit. Lordship.
Para 4?
Paragraph 4.
Yes, please read.
Lordship, that the office of the respondent had issued a tender for construction of the phase 1, package 2 building for Jawar DNV at Chari district by order dated so and so. Being successful, the petitioner was awarded the contract by order dated 25/2025. After issuing of the letter of the award, the contract was executed within parties by the paying the requisite stamp duty and the Indian stamp under as per the provision of the Indian Stamp Act. There were several conditions in the contract agreement as per the said contract agreement. Payments for the execution of the work will be made as per the conditions, specifications stated in the tender documents, and time of completion of the contract was within a period of 10 months, reckoned from 10th day from the issue of the letter of award. There was a specific condition in the letter that time is the essence of the contract, and if the petitioners fail to achieve the target works within the stipulated period of contract, the petitioners shall be liable to pay compensation for an amount calculated at the rates stipulated in clause 2 of the general conditions of contract. Further, clause 13.0 of section 1, instructions of tenders, the contract speaks about the court's jurisdiction. The said clause 13.0 is reproduced here in below. 13.0 court's jurisdiction. Any suit or application arising out of any dispute or differences on account of this tender or any matter in relation to the award of the contract or for enforcement of arbitration clause under the contract shall be filed in the competent court at Delhi only, and no other court or any other district of the country shall have any jurisdiction in the matter. As it is evident from the said clause of the contract agreement made between the parties, any suit or application arising out of any dispute or differences on account of tender or any matter in relation to the award of the contract or the enforcement of arbitration clause under the contract, the same shall be filed in a competent court at Delhi, New Delhi only, and no other courts of the other district of the country, and shall have no jurisdiction in the matter. As such, as per the clause 13 of contract agreement, the writ petition filed by the petitioner is not maintainable before this honorable court, and as such, the same is liable to be dismissed in limine. Tenders were invited letters of award issued, and agreements were executed by rights, with the petitioner acting as an agent for and on behalf of the Navodaya Vidyalaya Samiti. As per the Indian Contract Act, section 226 and 230, rights cannot be made a party in the matter. That the suit which has been filed does not lies against the rights being an agent of the disclosed principle. The petitioner has itself stated in paragraph 2 of its writ petition stated that respondent 2, 4, and 5 are acting for and on behalf of respondent 1, 3, and 6. As such, the respondent 2, 4, and 5 cannot be made a party because it is dealt with the subject matter in absence of any relief claim against it, and more so when it only an agent of respondent 1, 3, and 6. All actions were taken by rights as an agent of the respondent 1, 3, and 6, acting for and on behalf of respondent 1, 3, and 6. Therefore, respondent 1, 3, and 6 alone are the proper and necessary parties. Rights is liable to be deleted from the array of parties. The rights in reproducing below following portion of the notice inviting tender and instructions to tenders to show that respondent 2, 4, and 5 rights was a disclosed agent for respondent 1, 3, and 6 as principal, from whom the contract was awarded and had to be performed at the cost of respondent 1, 3, and 6. NIT 1. Sealed tenders in 2 package systems are inviting by the general manager, rights limited for and on behalf of the Navodaya Vidyalaya Samiti from contractors registered with CPWD, MES Railways PT, State Government Department, working contractors of rights limited for works. ITT 10.1 description of works. Sealed tenders are invited by rights for and on behalf of the client, i.e. MS Navodaya Vidyalaya Samiti, for construction of Navodaya Vidyalaya, for construction of Vidyalaya complexes, including infrastructure facilities such as roads, internals and external water supply lines, sanitary installations, along with internal and external electrification installation, etc. Further, clause 3.3 3.3 of the general conditions of contract reads as unders. All actions taken by REITs are for and on behalf of Novodaya Vidyalaya Samiti. The preamble of the agreement dated 22/8/2005 states that the contract has been awarded by respondent 2, 4, and 5 on behalf of respondent 1, 3, and 6. Further, the paragraph 1 of the letter of the award dated 25/2025 reads as under. REITs Rights Limit is pleased to issue you this letter of award on behalf of Novodaya Vidyalaya Samiti for the above-mentioned works on acceptance of your bid at the rates quoted by you in price bid document at 104% over DSR 97 for civil works, 70% for over SOR 94, and 95 for electrical works at the total contract price of rupees 4,36,00,000 1,897.26 paise. That thus it is eminently clear that the above contract documents that rights has throughout been proclaiming that it was acting as an agent on behalf of the respondent 1, 3, and 6, that is the NVS. In law, an agent is not liable or bound by a contract made on behalf of the principal. The following provisions of the Indian Contract Act are quoted below for kind perusal. Section 226 and 230 of the Indian Contract Act read as under. 226, Section 226 of the Indian Contract Act. Enforcement and consequences of agent's contracts entered into through an agent, and obligations arising from act done by legal consequences as if the contract had been entered into, and the acts done by the principal in person. Section 230. Agent cannot personally enforce nor be bound by contracts on behalf of principal. In the absence of a contract to that effect, an agent cannot personally enforce contract entered into by him on behalf of the principal, nor is he personally bound by them. Lordship. Lordship, with regard to the prior replies, Lordship, that with regard to the statement made in paragraph 5 of the repetition, while denying the same, it is replied that clause 5.3 under the section 3, page 182, special condition of contract of the contract agreement is reproduced herein below. Quote, all correspondence with rights shall be with the Deputy General Manager, CP Rights, third floor, left wing, Rights Bhavan, plot number 1, sector 29, Gurgaon, with a copy to engineer in charge, or as directed by them. Unquote. The contract agreement dated 22/8/2005 has been signed by General Manager, CP Rights Limited, and same authority filed letter dated 21/9/2022 has terminated the said contract. That with regard to statement made in paragraph 6 of the repetition, while denying the same, it is replied that the content of this paragraph, the paragraph, the petitioner is devoid of merit and not enabled for any such claim. It is also admitted the fact that petitioner filed letter dated 11/3/2005 has submitted that having examined the drawings, conditions of the contract, specifications, bill of quantities, etc., incorporated in the tender documents for the execution of the above named works, and having visited the examined the site of the said work, we then assign offer to execute, complete, and maintain the whole of the said works in conformity with the said drawings, condition of contract, specifications, bill of quantities, etc., for the sum as indicated in the bill of quantities, or such other sum as may be ascertained in accordance with the said condition. The copy is at page annexure 1. Annexure 1, page 29. Petitioner's letter, which I reproduced in my petition, in my affidavit in opposition. Further, the petitioner, by letter dated 11/3/2015, has submitted that, in para 1, I have read and examined all the conditions in the tender documents for the work of construction of phase 1, package 2, building for Jawahar Novodaya Vidyalaya at Chare District, Tingsang, Nagaland, and we hereby unconditionally accept the tender condition entirely for the above work. I undertake to execute the above items strictly in accordance with the requirements and particulars specifications speculated in the tender documents. Paragraph 4, I hereby further undertake that during the said period, I shall not vary, alter, or revoke my/our tender during the validity period of tender. I have quoted for the complete tender. I undertake to abide by the terms and conditions as stipulated in your tender documents and as amended thereafter. Paragraph 7, abide by and comply with all the terms, conditions, and provisions of the above mentioned tender documents. Lordship, that letter is annexed at Annexure 2, 31, page 31 and 32, Lordship.
Okay.
These are the letters of the
Yes.
petitioner. Lord. Clause 4.1 of Section 1, instructions to tenders of second contract agreement speaks about site visit. The said clause 1 is reproduced here in below. Page 10. 4.1 site visit. That the tender is advised to visit and examine the site of works and its surroundings and obtain for himself, for his own responsibilities, all information that may be necessary for preparing the bid and entering into the contract. The cost of any such visit shall be entirely at the bidder's own expense. The tenders are requested to satisfy themselves regarding the availability of water, requirement of electricity, nature and locality of work, the confirmation of the ground, the character, quality, and quantity of the materials, the character of equipments and facilities needed preliminary to and during the progress of the work, law and order situation, hindrance and or extortion of money by the local militant groups. Lordship, may kindly note this. The petitioner has raised objections that local militants and due to the distance from the capital or from the Dimapur till Chare is quite far, and the condition of the roads, all those, Lordship, all those they have met. But this is the condition that has to be fulfilled by the petitioners at the time of accepting the contract, Lordship. The general and local conditions, the labor conditions prevailing therein, and all other matters which can in any way affect the work under the contract. The contractor will be fully responsible. Lordship may note this. The contractor will be fully responsible for considering the financial effect of any or all of the above factors in his rates. No compensation will be given on account of ignorance or any of the factors during
He's
the
not
execution
asking
of the
for any
works.
compensation.
No, Lord. But
He's saying that they constructed a camp. He's
yes,
not asking for compensation, but he had to face the trouble.
as
That's
per
what
the
he's saying.
yes, Lordship. As per the clause, it's I'm reading the clause. But Lordship, the petitioners should have examined all those factors. So whether the militants or whether the militants come and camp there or they ask for money, and whether the conditions and the local conditions, the labor conditions of the petitioner, Lordship, those are the responsibility of the petitioners. Further to above, clause 9.1 of section 3, special condition contract of the contract agreement speaks about sufficiency of tender. They say clause 9.1 is reproduced here below. The contractor shall be deemed to have satisfied himself before tendering as to the correctness and sufficiency of his tender for the works and the rates and price quoted in the bill of quantities, which rates and price shall, except as otherwise provided, cover all his obligations under the contract and everything necessary for the proper completions and maintenance of the work. Lordship, reply to the subpara A, B, C, the claim of the petitioner is not tenable in view of the provisions of clause 4.1 and clause 9.1 of the contract agreement as reproduced above. Subpara D, the claim of the petitioner is devoid of merit and untrue. There was no written correspondence of the petitioner during the currency of the project of such claim. This is truly forcing a claim by the petitioner and is afterthought, Lordship.
Okay.
This was brought up after the contract was terminated. Subpara E, F, and G. The claim of the petitioner is not tenable in view of the provisions of Section 4 and Section 19 of the contract agreement as reproduced above, section subpara H. We strongly deny the claim of the petitioner. All additional substitute extra items of the works and their pricing have been executed and paid to the petitioner as per the provisions of the provision of clause 12 of general conditions of the contract agreement. The referred letter number so and so dated 26/9/11 of the general manager constructions NVS was a sanction on revised preliminary estimate and not the pricing of any item. That is referring to page 99 and 100 of the petitioner. Subparagraph I. Termination of the contract white letter dated 12/8/2013 by rights was strictly under provision of clause 3 of general conditions of the contract agreement. Civil suits filed before the principal district and session judge Tuing Sang and thereafter revocation of the contract is a matter of record which have been concluded with signing of supplementary agreement dated 11/4/2017 between the petitioner and rights, stating that all terms and conditions for completion of the project by the petitioner. It is pertinent to mention that as per the terms of supplementary agreement, the petitioner has to execute the leftover works with all prevailing terms and conditions of the original contract dated 22/8/2005. Lordship, that is supplementary agreement is at page 122 and 123.
Page how much?
122 and 123.
Okay, yes,
The
yes,
original
yes,
is 124 and 125, Lordship. The
yes.
petitioner has relied on that. Those also. Lordship, that with regard to the statement made in paragraph 7 of the petition, it submitted that the award of package 1 to MS Triveni Construction Private Limited is a private matter of record and termination thereof is as per the provision of the record. That with regard to the statement made in paragraph 8 of the petition is replied that the submission of the modified RERP by rights to NVS is a matter of record. That with regard to the statement made in paragraph 9 of the petition is relied that sanction of revised ANA and ENA amounting to rupees 13 crore 10 lakhs 90,000 by NVS is a matter of record. All additional substituted extra items of works and their pricing have been executed and paid to the petitioner as per the provision of clause 12 of the general conditions of the contract agreement. Further is submitted respectfully that in a similar case where it was filed for payment of additional works, Vice Playfield boundary wall fencing and retaining wall as per the revised price rate in aforesaid case I Tushi Longcomer versus Union of India and 5 others, WPC 263/2018 dated 19 was pleased to reject the case of the petitioner on the ground of jurisdiction issue. The relevant part of the order of the Honorable Court is as follows. This court deems it proper that the direction may be given to the petition. My apologies. Given that the matter may be placed before the appropriate forum, the petition stands disposed of as indicated above. Lordship, that has been that order
Is
order is annexed as at annexure 4, page 34 till 49. 34 till 49. The relevant portion is at page 49, the 2 last paragraphs. That with regard to the statement made in paragraph 10 of the petition, it is submitted that the principal partial completion of the school building was handed over by the petitioner to NVS is a matter of record. However, there is leftover work to be executed for school building, kitchen and dining, and other services and development works. That with regard to the statement made in paragraph 11 of the petition, it is replied that termination of the contract by already that 12/8/2013 was strictly as per clause 3 of general contract conditions of the contract agreement. That with regard to the statement made in paragraph 12 of the petition is submitted the termination of the contract by letter dated so and so, and communication rights letter dated 29/3/16 issued by the AGM CP directing the petitioner to deposit a total sum of rupees 2 crores 18,60,049 rupees 4,493 rupees was as per the comprehensive provision of clause 3 of general conditions of contract agreement. However, due payment amounting to rupees 9,38,000 have been paid to the petitioner on date 36/7 as such there is no or any liability pending with the petitioner. That with regard to the statement made in paragraph 13 of the writ petition, while denying the same, it is replied that the letter dated 29/6/2016 by the petitioner by rights requesting for settlement was as per the petitioner's will and there was no instruction, direction of the petitioner to do so. That with regard to the statement made in paragraph 14 of the writ petition, is replied that claim of the petitioner and interpretation thereof is devoid of true and fact. Supplementary agreement dated 11/4/2017 was signed by the petitioner without any conditional reference of any of the Contract Act as well as any articles of the Constitution of India. That with regard to the statement made in paragraph 15 of the writ petition, is replied that contents of the paragraph is not agreed to. Clause 4.1 of section 1, instruction of tenders of the contract agreement speaks about site visit. The said clause for this report is, Lordship, we have we have already gone through that on the site visit. 16. That with regard to statement made in paragraph 16 of the writ petition, is replied that the emails and corresponding letter of the petitioner referred to in this paragraph were not tenable. However, email dated 17/11/2019 by respondent was a request for a meeting to advise the petitioner by General Manager CP2 to resume work at site before its termination on account of abandonment of the site by the petitioner. That with regard to the statement made in paragraph 17 of the petition, is replied that letter dated 28/11/2019 by the Joint General Manager Civil Rights was issued for termination of the contract due to non-performance of the application by the petitioner. However, letter dated 2/12/2019 by the petitioner is not tenable. That with regard to statement made in paragraph 18 of the petition, is replied that emails dated 4/1/2020, 5/2020 by the petitioner to rights are not tenable. That with regards to the statement made in paragraph 19 of the petition, is replied that letter dated 22/7/2020 by the petitioner respondent is being devoid of merit and searching escape route by the petitioner to justify why he has not resumed the execution of work at site. As such, the aforesaid letter dated 22/7/2022 is not tenable in the eye of law. That with regard to the statement made in paragraph 20 of the petition, the deponent reiterated the statement made in paragraph 19 of this affidavit in opposition. That with regard to the statement made in paragraph 21 of the petition, it is replied that letter dated 22/8/2020 is mostly a matter of records. However, requesting all the details to provide total amount paid to the petitioner is considered irrelevant, as in numerous correspondence and in course of civil suit WPC, there has been elaborate accountals of the same. That with regard to the statement made in paragraph 22 of the petition, is replied that termination of the contract by order dated 21/9/2020 is not unilateral decision by the respondent. It is rather under the provision of clause 3 of the general conditions of the contract agreement, and largely on account of non-performance of obligations by the petitioner. That with regard to the statement made in paragraph 23 of the petition, is replied that termination of the contract was due to non-performance of the obligations by the petitioner, as they failed to execute the work as per the terms and conditions of the contract agreement. That with regard to the statement made in paragraph 24 of the petition, it is submitted that there is no provision in the contract of agreement for payment due to price escalation, Lordship. Lordship may note this, Lordship.
Okay.
That with regard to the statement made in paragraph 25 of the petition, while denying the same, it is replied that no additional projects were awarded to the petitioner. However, additional items were asked to be executed and thereby paid to the petitioner under the provisions of clause 12 of the general conditions of the contract agreement. That with regard to the statement made in paragraph 26 of the petition, it is replied that no circumstantial facts which were beyond the control of the petitioner has been reported to the respondent, which compelled him to resume leftover work under the provisions of the said contract act. Contract dated 22/5/2005. That with regard to the statement made in paragraph 27 of the petition, it is replied that the contents of this paragraph are devoid of merit. That with regard to the statement made in paragraph 28 of the petition, it is submitted there that no additional projects were awarded to the petitioner. However, additional items were asked to be executed and thereby paid to the petitioner under the provision of clause 12 of general conditions of the contract agreement. Further, contract has been terminated by the correspondent on account of non-performance of the obligations by the petitioner in accordance with clause 3 of general conditions of the contract agreement. As such, the petitioner is not permitted to complete the remaining unexecuted work and they were terminated from the contract. That with regard to statement made in paragraph 29 of the rate petition, it submitted that there is no provision or of revised rate in the contract and therefore arguing to pay in revised rate is not tenable. Lordship. That with regard to the statement made in paragraph 30 of the rate petition, it submitted that in interpretation of clause 13.0 at page 113 of the contract agreement by the petitioner is not agreed to. It is pertinent to mention here that the Honorable Gauhati High Court so and so Lordship that has been already submitted. That with regard to the statement made in paragraph 31 of the petition, it is replied that the contents of the paragraph are devoid and merit hence denied. That with regard to the statement made in paragraph 31 of the petition, it is replied that the contents of the paragraph are devoid of merit and since denied. That with regard to the petition made in paragraph 34 of the petition is submitted that contract has been terminated by the respondent on account of non-performance obligations by the petitioners in accordance with clause 3 of the general contracts condition of contract of the agreement, the forfeiture of security deposit and recoverable security deposit were as per the provisions of the agreement with the petitioner. Lordship. That with regard to the statement made in paragraph 35 of the petition, the respondent begs to offer no comments. That with regard to the statement made in paragraph 37 of the petition, while denying the same, it is submitted that there is no provision of revised rate in the contract and therefore arguing to pay in revised rate is not tenable. That with regard to the statement made in paragraph 38 of the petition, while denying the same, it is submitted that all additional substitute extra items of the work and their pricings have been executed on paid to the petitioner as per the provisions of clause 12 of the general conditions of the contract agreement. The referred letter dated so and so 26/9/2011 of General Manager Construction NVS was a sanction of revised preliminary estimate and not the pricing of any item. That with Lordship will notice.
Okay,
The sanction was revised preliminary estimate and not for pricing of any item.
okay.
Paragraph 39. While denying the same, it is admitted that the contract has been terminated by the respondent on account of non-performance of the obligations under this clause 3. Lordship. That with regard to the statement made in paragraph 43 of the petition, it is replied that the petitioner failed to execute the contract work as per the terms and conditions of the contract agreement dated 2025, as well as the supplementary agreement dated 11/4/2017. The petitioner miserably failed to execute the contract work after giving him adequate time and opportunities, and even after issuance of reminders, notice in writing, they failed to do so without any reasonable cause. Having no option left with the respondent, it was constrained to issue the letter of termination of contract work dated 21/9/2020. Hence, the respondent rightly proceeded as per the provisions of the contract agreement. Further to the above, it is relied that any additional work executed to be executed in the contract was strictly bound by clause 12, section 2 of the general conditions of the contract agreement. The rate of such additional work is to be determined by the engineer in charge as per the provisions of clause 12.1.2, section 2 of the general conditions of the contract, and the engineer in charge shall have the power to make alteration in omission from conditions to substitution, etc. during the progress of work, and the contractor shall be bound to carry out the works in accordance with the instructions given by him in writing on the same condition in all respects, including price on which he has agreed to do the main work. In view of the above, it is respectfully submitted that the determination of rates for additional items executed is well defined in the contract agreement made between the parties. Paragraph 44. It is replied that the petitioner failed to execute the work as per the terms and conditions of the contract agreement. The petitioner miserably failed to execute the contract work after giving adequate time and opportunities, and even after issuance of reminders in writing, they failed to do so without reasonable cause. Having no option left with the respondent is constrained to issue the letter of termination order dated 21/19/2022. Paragraph 47. While denying the same, it is submitted that we strongly deny the statements made by the petitioner. Deny the statements of the petitioner. Clause 5.3 at page 182 of under the section 3 special condition of contract of the contract agreement is reproduced here and below. All correspondence with rights shall be with the deputy manager. CP rights 3rd floor, left wing rights Bhavan, plot 1, sector 29, Gurgaon, 122, with a copy of the engineer in charge as directed by them. The contract agreement dated 8 to unfold has been signed by General Manager and same authority white letter 2192 has terminated 2020 has terminated the said contract. Lordship, since Lordship, some of the paragraphs are repetition, Lordship, I may
Yes,
be
yes,
allowed
you
to
can see
go to
there are
page
lot
para
of
55.
the termination.
Yes, yes,
Part is repeated twice, I think.
yes. Lordship, but this has to be bring to the notice of the court that it was due to the
I
incompletion of the
understand.
petitioner. We have to
Yes, yes, terminated.
the contract was terminated. Lordship may come to page 26, paragraph 55. That with regard to statement made in paragraph 55 of the writ petition, while denying the same, it is replied that the petitioner failed to execute the contract work as per the terms and conditions of the contract agreement. The petitioner miserably failed to execute the work after giving him adequate time and opportunity, and even after issuance of reminders, notice in writing, they failed to do so without any reasonable clause. Moreover, even after issuance of the show cause notice, the petitioner never resumed execution of work as cited while clearing established precarious situation and casual attitude of the petitioner. Having no option left with the respondent, was constrained to issue the letter of termination of the contract work on 21/9/2020 and subsequently by letter dated 14/11/2020 issued by the office of the respondent. The petitioner was directed to deposit a total amount of rupees 84,977.70 paise, and the respondent rightly deposited as per the provision of the contract agreement entered into the petitioner. That in view of the replies stated above, the relief sought by the petitioner be rejected and the petitioner may be dismissed with exemplary clause by this honorable court. Much obliged.
We are allowed to make a brief reply. I'll take only 5 minutes.
Okay.
I appreciate the honest and candid submissions made by the counsel for the respondents 1, 3, and 6, in which he have read out paragraph 6 of his affidavit. Now, my lord is well aware that admitted facts need not be proved as per section 58 of the Indian Evidence Act. So it is an admitted fact that the cost was revised in 2011. Now, so far as the judgment and order passed in WBC 263K 2018, which has been annexed in the, it has been set aside by the division bench.
Okay.
Now, paragraph 2 will show my lord that it deals with, it is an appeal, writ appeal, intra-court appeal arising out of 263 of 2018. I may be allowed to read paragraph 11 from that. Mr. Imdi Longchin,
Para 5.
para 11, para 11. I have given the original CDC.
Oh.
It's okay, it's all right. It's all right, it's okay.
Oh, this is a certified copy.
Yes, yes. But it's all right. I will another one. It's all right.
I have already noted it.
No, it's okay, it's okay, it's okay. No issues.
You will have to ask for another one.
In para 11, Mr. Indil Longchim, the learned counsel for the appellant, submits that the learned judge had erred in coming to the above conclusion since the jurisdiction of the court cannot be ousted by a civil agreement. In support of his submission, he has cited the following decisions. So he has cited 2 or 3 decisions passed by the Honorable Apex Court. And in para 20, we have observed that the learned single judge had not touched upon the merits of the case, but had disposed the writ petition on its maintainability only. We are therefore constrained to set aside the order of the single bench dated 9/4/2021 by remanding the matter back to the single judge for disposal of the writ petition on merits. So on the issue of jurisdiction, it was dismissed. An appeal was preferred before the division bench, and division bench said that no, it has to be remanded back. This is regard the 3 additional works and payment as per the 2005 rate. Now, even as it is, the work order was issued from Haryana, Gurgaon, and the impugned letters Annexure 27 and Annexure 33 are 33. They are also issued from Gurgaon, Haryana. So no part of the cause of action arose in New Delhi. Therefore, the question of conferring jurisdiction to a court in New Delhi, a civil judge or a writ court, it does not arise. They are saying that as per clause 13, the matter has to be taken up in a Delhi court. A private agreement cannot confer jurisdiction. Since no cause of action arose in New Delhi, the work order was awarded at page 65. It is annexed the original work order. It was issued from Gurgaon, Haryana. Because rights office is at Gurgaon, Haryana, not in NCT Delhi. Now, state is a model employer. This legal principle is well settled. And it deals not only with service law, but contract as well. Because here also the state has employed me. I am the employee. And the state should not try to exploit its citizens. And now it is not the state's money, it is my money that they have withheld. Therefore, that amount must be given back to me. I may not be allowed to repeat whatever I have stated.
Yes.
Now, lastly, my learned friend has stated that I should have foreseen at the time of entering into the contract the circumstances that would arise. Now, the doctrine of reasonable foresight, or reasonable foreseeability. Wacken Mount's case, it is the leading case. Now, in that case, my lord is well aware that oil spilled from the ship called Wacken Mount, and later from that oil, it flowed into a welding unit. From there, due to the sparks from the welding unit, fire was caught. The court said that no, that oil was not known to be a particularly flammable oil, and it was not foreseeable for the Wacken Mount vessel that fire will occur from the oil leakage. Therefore, here also, there was a breach in Sesong River. If there was no breach, that is one thing. There was a breach. It was reasonably foreseeable for me that I will be able to utilize that bridge, that road, to carry my materials. It was not foreseeable for me that force majeure will occur, the bridge will collapse, flood will take that bridge away. Now, if the insurgents were camped at the work site, when the work order was awarded or when these agreements were entered, it was reasonably foreseeable for me that I will not be able to execute the contract. But it was a vacant plot. Now, when I executed the work in the partly constructed building, when the insurgents came and resided there, it was not reasonably foreseeable for me that these people will come. It was not reasonably foreseeable for me that when these people come, the laborers will run away. And then it became very difficult for me to mobilize labor again because they became scared. Also, it was not reasonably foreseeable for me that the engineer from Rights will be abducted by the insurgents, demanding ransom.
Okay.
Roads were washed away, bridges were washed away. And it was not foreseeable for me also that the Rights themselves will provide me the working drawings, sketches in a delayed manner. And that financial progress was also very slow. Now, I have caused no loss to the respondents. And it is my money, not their money. Therefore, that may be given to me, and interest rate as per section 34 of the CBC, as deemed fit by this honorable court, may be imposed. I rest. Much obliged.
This is item number?
19. This is the last item, I believe, for
I
today.
think so.
Yes.
Third learned counsel, Mr.
Sentianger, my lord.
Sentianger for the petitioner, comma. Learned counsel, Mr. Foseko, huh? Sorry, learned, oh, cannot get your name. CGC, na?
Yes.
CGC, লিখি দেন নামটো লিখি দিবা। For respond number 1, 3, and 6.
Yes.
CGC. Learned counsel, Mr. Foseko. Fote for the respond number 2, 4, and 5. Okay, and hobo de, মাজতে comma and এটা hobo. Reserve for judgment and order.
Deeply obliged.
और नहीं, और नहीं है ना? এটা লিখে দিবা। I'll need the printouts of those judgments. Yes, I'm so sorry.
No,
about
it's okay,
this.
it's okay, it's all right, it's okay. No
You
issue.
take it back, I'll just.
No, it's okay, it's okay, it's all right.
It
You can
won't
keep
be
it.
helpful also. You cannot submit anywhere because I haven't.
No, it's okay, it's, I will.
I didn't see, I didn't
Another,
notice
another
actually.
copy.
I should have
It's
noticed.
all right. It's not an issue. Deeply obliged.